Hi, my name is Stanley Zamora. I'm a Florida Supreme Court certified mediator. And something just so interesting happened in the mediation that ended, I had to share. So this is the usual case where you have parties on both sides, sophisticated general counsel on the defense side, sophisticated litigant on one side. The attorneys came, partners, 4 on one side, 3 on the other side, whatever it was dynamic-wise. Here's the interesting part. As the defense was given their opening statements, they actually stated, I thought partner such and such from your firm would be there. And the plaintiff had already gone. From the plaintiff side said, oh, that partner will be showing up later on. And they said, oh, interesting, because I haven't seen them since law school. And smiled. We carried on. That person eventually did show up in the middle of the defendant's counsel's opening statement. Within that time frame, they actually paused the opening statement, which was a little bit weird, and said their hellos and salutations and such, and then got back to completing the opening statements. We eventually separated into caucusing, and during the caucusing, round 3 or 4, where numbers are pretty far apart, the defense said, can you have just that partner firm blah 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 come in? And I said, okay, I'll ask. So then I went to the other side and said, would you mind if I borrow your attorney, please? And general counsel, blah, blah, blah. And also partner, would you mind coming in to the other room? They'd like to speak with you about something regarding the case. And when I brought them into the room, the defense immediately told the general counsel immediately general counsel immediately told the attorney for the defense, this is not typical mediation. So just watch. And they started going back and forth about numbers and estimates, but in a very pleasant way. And then, out of nowhere, a number was presented. A number that the defense, from the beginning, the round 2 and 3, was nowhere near. We're talking like five figures, tens of thousands of dollars higher. And then on the other side, they were in the pretty decent high figures. Their number got lower, and they said, we're not sure if it'll be acceptable yet. Let's go speak to our client first. They went to talk to their client. And while the defense, when I was in the room with the defense counsel and the corporate rep, we're having a conversation, and the corporate rep, who was also an attorney, said to the attorney, you see, this is not the typical mediation. Mediation is not like this. And I paused her and said, you know what, correction. Mediation can be like this. Mediation should be like this, but for some reason, people want it to remain antagonistic. People want it to not be a conversation, which it really should be. Mediation can be a conversation where we can constructively look at our case, see perspective, build a dynamic that does something else. Does something different. It doesn't have to be the space and the place where we try our case. That's important. Merits of the case is important. How we see the case is important. How we weigh, how maybe a judge or a jury might look at the case is important. But it is not the only way in which to resolve a case. In fact, I think that's like 10 or 15%. Guess what happened? It resolved with a settlement agreement. Not saying that's the only goal, but that was the goal that they both wanted to achieve. And they achieved it in what she stated as not the typical way. By coming together and figuring out, what do the attorneys need? What do the attorneys want? What does the client want? What does the client need? So guess what? Flexibility in the process, inviting parties into their process and being free of what they think is a structure so formal that they cannot be creative. It works. In fact, when they were signing the agreement, the general counsel of the corporation on the defense side said, "I'm sorry for taking over. I shouldn't have done that, but I'm glad we resolved it." And I paused her again. Now we're in joint session. I said, if you don't mind me mentioning what I mentioned to you in private caucus session, this is your process. And you engaged in this process the way you needed to engage in this process this time. Now, it may not happen again the next time, but what if it does? What if you start to negotiate and mediate like having a conversation to resolve the issue? We will go through the merits. We'll go through all of the things and points that you find important. But then we're going to get down to what the needs and wants are of the parties, what the needs and wants are of the participants. That's important too. And then you find a solution that works for you. So with that, 1, mediation is flexible, so should you be. 2, invite parties into their process. And 3, be formless, be shapeless, be water, my friends. It doesn't have to be like the other ones we had in the past. It can be something different. But it's up to the mediators to make that happen. We set the tone. We're the guardian of the process for them. With that, thank you. Have a pleasant rest of your day.